Thank you, Terry, and thank you, everyone else. Before coming here tonight, I made up my mind I would make one serious comment before I get through. But since I've been here, I thought of a lot of other things I want to say, and I won't talk forever. But one of the first is that I had a bone to pick with Anthony Graves, who is here today, and I had a chance to express to him the problem that he created for me, because I was in Houston in October of last year, and before going down there, a reporter for the Houston paper, I don't remember the paper, went to great lengths to arrange a special interview with me. They don't have Supreme Court justices come to Houston every day, I guess, so I thought it was sort of a big deal that he arranged this interview. And just before the interview was to take place, he called up and canceled. And I thought, that's pretty rude. Why are you canceled? He said, well, he had something much more important on the agenda, and it was, of course, they had just learned about Anthony being proved innocent, and of course that was a big story at the time. But you caused me all sorts of trouble. But I have to say, I think maybe the reporter had correct priorities in what he was doing. Of course, I also want to congratulate those of you who've been specially mentioned tonight, and all of you for your work. And Terry's quote from what I said some time ago prompts me to comment on one experience that I had doing pro bono work. Gosh, it must be 50 or 60 years ago. It's the kind of thing that you remember. I had never handled a death case, but I did have a case involving an inmate at Joliet who had been in prison for, I think, 16 or 17 years at the time I began to represent him. And he had alleged in a case, in filing, there was the sufficiency of his pleading was finally upheld after going to the Supreme Court, and thereafter I was appointed to represent him. He had alleged that the police had extorted a confession from him by handcuffing his hands behind his back and hoisting him over a door, and then they beat him rather brutally with different implements until he confessed. And I was interested in trying to form a judgment about the veracity of his allegations, and so on my first meeting with him in his cell in Joliet, I asked him about the pain that was caused by the handcuffing behind and the hoisting on the air, and asked him to describe it for me a little bit, and I was expecting him to tell me what the particular impact on his wrists, where the metal handcuffs had to come. And when he said, it just killed my upper shoulder. The pain in my shoulders and my upper arms was absolutely excruciating, and he didn't even mention the handcuffs. And I sat there and I thought, by golly, this guy's telling the truth. And I was completely convinced of the truth of what he had to say. And to make a long story short, we had an evidentiary hearing, and we proved that really, without any shadow of a doubt, that his story was absolutely true. And one of the most persuasive part of the record was the cross-examination of the police chief, who testified that he'd fallen down the stairs in the police station and suffered bruises that couldn't possibly match those that the medical records established. But I mention this story because I have said, and I'm sure some of the rest of you said, is that the greatest reward in some of your professional experiences is not the monetary reward or the pride in your result, but it's some of the psychic pleasure that you get out of realizing that you've been able to do something that's very worthwhile for somebody who really is in need of help. And the reason I describe that incident is I still think about that conversation, even though it occurred back in over 60 years ago. So you, I know, and all of you have experienced similar situations where you have understood the value of what you're doing and the pride you take in what you've accomplished. But the serious point I wanted to make tonight and planned on saying was I must say Brian Stevenson is one of my heroes, too. I first got to know Brian at Aspen, Colorado, at a seminar that he and I both participated in at the same time. And I've been a great admirer of his work. And he asked me to come to New York earlier this summer to talk to his group in New York. And that was shortly after the decision in the, I never remember case names. My law clerks will verify that. You should ask that. But it's the case arising out of Louisiana, in which the defendant had been wrongly convicted because the prosecutors withheld exculpatory evidence that was plainly in violation of their duty. You know the case. You'll tell me the name of the case, and I'll recognize it, of course. But the point I wanted to make was that there was a debate in the Supreme Court decision between, I think Justice Thomas wrote the majority and Justice Scalia concurred, and Justice Ginsburg wrote the dissent. But the basic argument was about whether or not the plaintiff had adequately proved inadequate training on the part of the prosecutors, which explained the violation. And the more I thought about that case, the more it's really off the wall to say that the issue should depend on whether or not they had proper training or not. They're clearly, and this goes back to Oklahoma City against Tuttle and Monell, there clearly should be a rule where respondeat superior applies and imposes liability on the employer for acts committed in the course of their employment that caused the harm. Here you've got an unquestioned proof of the constitutional violation and the harm, and the law doesn't just provide a very obvious answer that it would provide in normal tort litigation against the government or corporate employers or any other. They have to go through all this folderol about whether or not the training was good over the period of years. And the rule is so obviously unwise that somebody ought to do some work about changing that rule. And I know the legislature would have to be involved in it, but I just cannot. And of course, just to digress one more point, the reasoning behind the decision, both in Monell and in Oklahoma City, rested on the interpretation of legislative history of 1983, in which the Congress declined to enact the Sherman Amendment, which would have imposed liability on municipalities for failing to prevent riots to occur. And they said that shows they didn't want respondeat superior. The argument is totally unconvincing. And so anyway, I don't mean to bore you with one particular issue, but it just seems to me that that's an issue that is so dramatically wrong and causes so much work in many of your cases to be litigating the adequacy of the training of people who have committed flagrant constitutional violations. But I thank you very much for letting me share these this evening tonight. I really appreciate the demonstration. The pictorial account was very effective, and it's been a very nice evening. I congratulate all of you for what you're doing. Thank you.